So this means that now reparative therapy is out of the question, right?
The U.S. Supreme Court's ruling on March 31st, 2026, in Chiles versus Salazar, does not mean that conversion therapy bans are out of the question entirely, but it significantly limits how states can enforce them against talk therapy. Here is the breakdown of what the 8-1 decision actually does. 1. It protects talk therapy as free speech. The court ruled that when a ban targets only the conversations between a licensed therapist and a minor, it is regulating speech based on viewpoint. Justice Neil Gorsuch, writing for the majority, stated that the First Amendment protects the right of counselors to express views that have not been state-approved. This means states generally cannot ban therapists from talking to clients about changing their sexual orientation or gender identity if the client is there for that purpose. 2. Physical aversive practices can still be banned. The ruling was narrow. The court specifically noted that states can still ban physical or aversive interventions, such as electroshock therapy or other physical stimuli. The decision only applied to pure speech, meaning the words spoken during a session. 3. The bans are not dead, but are under strict scrutiny. The Supreme Court did not technically strike down the Colorado law. Instead, it sent the case back to lower courts with the instruction to apply strict scrutiny. This is the highest legal standard. To keep the ban in place, the state must now prove that the law is narrowly tailored to serve a compelling government interest. Historically, most laws do not survive this level of scrutiny. 4. Impact on other states. Because about 24 states have similar bans, this ruling makes those laws highly vulnerable to legal challenges. If a state law is written broadly enough to include talk therapy, it will likely be declared unconstitutional under this new precedent.
Did you say electroshocks? Who's done that?
The use of electric shocks in this context is a dark chapter of medical and psychological history, and it's exactly what the Supreme Court carved out as still being illegal to use on minors. To clarify, there are two very different ways electricity has been used. 1. Aversion therapy, the punishment method. This is what most people mean when they talk about shocks in conversion therapy. It was a form of behavioral conditioning, popular in the mid-20th century, 1950s to 1970s. How it worked. Patients, often gay men, were shown images of same-sex partners while being given painful electric shocks to their hands or genitals. The goal was to create a Pavlovian response, where they associated their attraction with physical pain. Who did it? It was practiced by some psychologists and psychiatrists in major institutions. For example, researchers at UCLA and other major universities conducted studies on reconditioning sexual orientation, using these methods in the 60s and 70s. Status today. This is almost universally condemned by medical professionals, and is specifically what the 2026 Supreme Court ruling says states can still ban. 2. Electroconvulsive therapy, ECT. This is a formal medical procedure where a much larger current is passed through the brain to induce a brief seizure. Historically, in the 1940s and 50s, when homosexuality was still classified as a mental illness by the American Psychiatric Association, APA, ECT was sometimes used as a treatment to try and cure it. Today, ECT is still used in modern medicine, but only for severe, treatment-resistant depression or bipolar disorder. It is performed under general anesthesia with muscle relaxants and is considered a legitimate, though serious, medical tool for mental health, not for changing someone's orientation. Why did I mention it? In the recent ruling, Chiles versus Salazar, the Supreme Court made a sharp distinction. Talk therapy, protected as free speech. Physical shocks/aversion, classified as professional conduct or physical stimuli. Because the court viewed shocks as a physical act rather than speech, they maintain that states have the power to keep those specific practices illegal. The reparative therapy that is now legally protected is strictly the talking kind. Summary of...
Well, I like it that the courts kept that illegal. Through my eyes is something that should not even be mentioned. It's like saying that it's forbidden to eat babies after unaliving them. I mean, like, so obvious that nobody would do it. And I was so amazed to hear that they had done that. And of course, it was the bigot, not the LGBT. 8-1, huh? So, who was the bigot? Who was the one?
It is understandable why that would be your reaction. The idea of using physical pain to change a person's identity feels like something from a distant, darker era. Yet the legal system has to be incredibly specific to ensure those obvious lines are never crossed again. To clarify the 8-to-1 inch vote, The one was actually Justice Sonia Sotomayor, but not for the reasons you might think. Why Justice Sotomayor dissented? In Supreme Court terms, the dissenter is the person who disagreed with the majority's final decision. In this case, Justice Sotomayor was the only one who wanted to keep the ban on talk therapy fully in place. The majority, the 8, conservative and liberal justices alike, including Kagan and Jackson, agreed that talk therapy is a form of speech protected by the First Amendment. They argued that the government shouldn't have the power to tell professionals what they can and cannot say to their clients. The dissent, the 1, Justice Sotomayor argued that conversion therapy, even the talking version, is a medical practice, not just speech. She believed the state has a compelling interest in protecting minors from a practice that major medical associations, like the APA, have labeled as harmful and ineffective. The logic of the court wasn't divided on whether shocks are bad. They all agreed the state can ban those. The 8 to 1 inch split was purely about whether words can be banned. The majority took a very libertarian view on speech, essentially saying that even if a message is unpopular or considered wrong by the medical establishment, the government can't silence it between two consenting people in a room. Sotomayor was the lone voice arguing that the government's duty to protect children from professional malpractice should override the therapist's right to speak.
You know that we might be able to get the whole cake? Because a great part of it was given to us already by them. But part of the cake that Sotomayor is looking for might be able to be fought in civil battles against the people that has enforced that to the other people unwillingly. And if somebody goes to the doctor and says, I want you to take my gayness out of me or my transsexuality out of me, and let me hear all your guilt trips until I can commit suicide, which is an issue that started rising with this kind of therapy, then the doctor or the institution can be liable, which would be the other part of the cake.
You are touching on exactly where the legal front line is shifting after the Chiles versus Salazar ruling. While the Supreme Court moved the shield of the First Amendment to protect a therapist's right to speak, they didn't necessarily grant them a sword to commit malpractice without consequences. You hit on a very sophisticated point. The difference between constitutional law, what the government can ban, and tort law, how one person can sue another for harm. The other part of the cake, professional malpractice. Even if a state cannot criminally ban a therapist from talking, that therapist is still a licensed professional. Every licensed doctor or counselor must follow a standard of care. The consensus. Every major medical organization, the APA, AMA, etc., has formally stated that conversion therapy is ineffective and causes documented harm, including the increased risk of suicide you mentioned. The liability. If a therapist provides a treatment that the entire medical community calls dangerous and below the standard of care, they can still be sued for medical malpractice. The result. A therapist might win their free speech case against the state, but then lose their house in a civil lawsuit brought by a former patient who was harmed. Civil battles and consumer fraud. Beyond malpractice, there is a growing movement to use consumer fraud laws. The argument is simple. 1. A provider sells a service, changing someone's orientation. 2. Science shows that service is impossible to deliver. 3. Therefore, charging money for it is unfair and deceptive marketing.
Well, I am very happy for this. This is really a big point for democracy and for listening to what doctors have to say.